My name is Bradford Colbert. I'm the Director of Legal Assistance to Minnesota Prisoners here at the Law School. Before that, I was an appellate public defender for, well, let's just say a long time. We are here this morning to talk about prosecutorial resentencing. Minnesota joined several states that passed legislation that allow prosecutors to ask the court to resentence people. Now, if you told me 10 years ago that the legislature passed a law allowing prosecutors to ask for resentencing, I would presume that meant they go back to court to ask for longer sentences. That's not the way this legislation works. Here, the prosecutors are going to be able to go back to court to ask for shorter sentences. This is a fascinating new law, and we have three fascinating people to talk about with us. We'll let them introduce themselves. So we'll start with you, Hillary, because you came the longest.
Hi, everybody. It's great to be here. My name is Hillary Blount. I'm the founder and the executive director of an organization. It's a national nonprofit. We're called For the People. I'm a former prosecutor that spent some time doing reform work and sort of noticed that in the reform space there were not a lot of prosecutors in that space. So I founded my organization to basically invite and encourage more and more prosecutors to be involved with reforming the justice system. As a prosecutor myself, I often talk about the harm that was caused by the actions that I took without really realizing or recognizing what happens to people after they were sentenced. It just wasn't something that we were ever taught or thought about. And so my mission is to get more and more prosecutors to think about what happens after they ask for a 50, 100-year to life sentence. And this concept of ongoing justice, which means that their job is to do justice at the time of sentencing. 5, 10, 20 years later, it's their job to make sure that every person in prison, if they can be safely released, then any day that they're in prison after that is an excessive sentence, and prosecutors have an obligation to do something about that. So it's really great to be here.
Mary will let you go next since she came all the way across the river.
That's right. I'm in John Choi's space here. Thank you. My name is Mary Moriarty. I was going to say newly elected, but I don't think I can say that anymore. Hennepin County Attorney. I took office in January. Before that, I was the Hennepin County Chief Public Defender and a public defender in Hennepin County for over 30 years. And one of the reasons this is so important to me is that when you work in a system that does have sentencing guidelines and no actual opportunity or tool for prosecutors or anybody else to really look back and see what's happened to a person. I always wondered that too. People would go to prison and how are they doing? Where are they now? Do they really need to be there? And until now, there really hasn't been much of a mechanism or a tool. And I'm especially excited about database approaches, which this is. So I'm very excited to be here. Thank you.
Thanks. John, you're just in the neighborhood, so.
Great. Well, good morning, everybody. I'm really happy to be here talking about this really, I think, great legislation that passed with both Mary Moriarty and Hillary Blount. I first came to this work because I was really inspired by some of the work that Dan Satterberg in King County, he was the elected district attorney there. He started talking about this issue about resentencing. And then I heard Hillary speak, and then we made some connections, and we started working on this type of work. And actually in our office, we were always trying to do some adjustments with sentencings, maybe to help somebody to mitigate collateral consequence, but there was never really a clear path. We were kind of doing this work really under the radar. And we always thought when we were doing that there wasn't this clear path. And so learning more about what happened in California with their legislation passing and meeting with Hillary and her organization, we started working on this legislation in Minnesota back in probably about 2019. It was before the pandemic. And we were not successful that first session, but finally we were able to get it over to the finish line. And this past session, so many great things happened. This is one of them. And I really believe that the prosecutor in their role as a minister of justice cannot obviously certainly only be about securing convictions. It has to be about doing justice. And for me, that means that we need to be thinking about what happens to somebody after they are sentenced, they are sent to prison. We have to be focused on reentry. We have to be thinking about what kind of rehabilitation actually happens during that time period. And we should embrace these values that I think do not live very well in the criminal legal system, which are the values that we have as a society around reconciliation, redemption, restoration. In our places of worship across this nation and this community, we talk about those things and we try to model those things in our personal lives. But in the criminal legal system, those aspects of mercy and things like that, they don't live very well. And so we need to lift those up, and so that it's a regular part of what justice is.
Thank you. Hillary, why don't you start us off and give us the national perspective and how this started?
Sure. So as I mentioned, I run an organization called For the People, which was intentional, right? Every day prosecutors stand up and they say, I would say I'm Hillary Blount, I represent the people. But the people, right, that's supposed to be community, it's supposed to be people who are incarcerated, it's supposed to be their families, and also victims as well. And so we started this organization after the first law passed. So prosecutor-initiated resentencing, the first law that was passed in the country was in California. The law is very simple. It's that the prosecutor makes a recommendation to court, and then the court has jurisdiction to hear the case as if the person had not been sentenced before. The sentence cannot go up. It is required that it can only be lesser, and it has to be legal. And as Mary was saying, that there weren't very many mechanisms. It was basically the governor's pardon pen, or it was the parole board, or you had to pass some legislation. But there weren't a lot of ways for people to get out. Lots of ways to send people to prison, but not a lot of ways for people to be released. And so PIR, as we call it, was passed in California, and then subsequent to that, the law was passed in Washington State, in Oregon, in Illinois, and then now most recently here in Minnesota. I will tell you that in the beginning, there was a lot of resistance, as you can imagine, right? A lot of prosecutors saying, this isn't my job, and how would this even work in practice, and this sounds really dangerous, and what about victims? And we're really pleased to say that now that the law has been around for several years, about 1,000 people have been resentenced across the country. There's about 34 prosecutor offices across the country that are using prosecutor-initiated resentencing in the states that I mentioned, or as John mentioned, they're using some other kind of alternative mechanism. So there are other mechanisms. Oftentimes prosecutors find that it's a bit of a legal fiction, but they're going to do it anyway because there's suffering and relief needs to be delivered for a person's case. But just to give you a flavor of the number of offices that are engaged in this work, and oftentimes in these offices, they are either initiating the cases themselves, they're joining in motions with defense. So about 1,000 people, as I mentioned, have been resentenced since this law was initially passed. I'll also just mention that one of the aspects of this that was surprising to us, for us there was not enough effort happening on, quote, back-end work, right? There was a lot of front-end reform that was happening. And for us, it felt like there were all these statistics about the adolescent brain, or about how people can rehabilitate and people change. And all of these statistics were being put forward as ways to change things on the front end. We've got to change policies on the front end because look at what happens if you don't. And our approach was, well, yeah, look at what happens if you don't. And what about all the people that are in prison right now that aren't going to get the benefit of this new thinking? And so that was the main focus, was to try to get as many people out of prison that could be safely released. But one of the things that also happened, and we've seen this across the country, is that it's actually making communities safer. Surprise, surprise, right? When you reunite families and you reunite communities, it makes our communities stronger. And so as prosecutors, our job is public safety, it's community safety. And so we're really excited to be able to show that. It was anecdotal at first, but be able to show that the people that are coming home are walking their kids to school and allowing their spouses to go back to work. Anyone here that has had a loved one inside knows how expensive it is to sort of support and keep your family together through that kind of separation. And so this is another aspect of it that we feel is, we kind of knew it anecdotally, but to have prosecutors really be able to see it in practice, that this work is actually making communities safer, I think is another reason we're seeing so many prosecutors engage in this work. Not all prosecutors, not yet. It does take time to educate and bring people along, but I think this aspect of it has been really compelling for prosecutors around this notion of public safety.
Mary John, you want to give us the Minnesota perspective, and maybe you can talk about what your respective counties are doing? Well, how did it come to pass in Minnesota?
Sure. I think some statistics are really important here. Between 1980 and 2010, our incarceration grew 222%. And there was no increase in crime that led to that. We know that this resulted primarily from sentencing policies. We know that lots of people spend a lot more time in prison. We're sending more people to prison for a lot longer. And I think it's really important to be intellectually honest about why we are embracing this. This is about public safety. It is about equity. And to give you an example of some of those numbers, 25% of Minnesota's prison population came from Hennepin County. And within that 25%, 69% of those people are Black. And the population in Hennepin County is about 14% Black. So we know prosecutors, we have been responsible for this huge increase in incarceration, which has not made us safer. And so this is an opportunity for us, I think, in many respects, to rectify the wrongs of the past and to actually acknowledge the harm that has been done by these harsh sentencing policies that do not make us safer. So I'll hand it over to you, John.
Well, thanks. I think those numbers and those statistics are really important, because I think a part of this work too should be grounded in racial equity. It should also be grounded in recognizing that if there are people that are in prison today that had sentences that just don't make sense today, those are things that I think that we should be thinking about. And so here in Minnesota, it's been kind of a long journey, because this role of getting the prosecutor to be in this space, as we were talking about this law with my colleagues in Minnesota, there were so many barriers of people embracing this. And I want to give credit to my colleagues for ultimately getting to a place where they said that we should give this a try. But my biggest worry is that it's only going to be one or two or three small, or few of us that will be doing this. And so it's really important for all of you to be having conversations with your elected county attorneys to ask them to consider this and to do it in a very, very sincere way. But some of the challenges of thinking about this from a prosecutorial standpoint, I mean, I think the first thing that we heard oftentimes was, well, this is going to increase the administrative, burden that we have, and isn't kind of like is this the job of the corrections officials, because they would be in a better place to understand who should be released, and aren't there mechanisms by which they could have that relief? So they would point to the fact that you could be paroled, or there's commutations and things of that sort. But the reality is that the commutation, the pardon board only meets a certain amount of times a year. They can only take on so many things. And at the end of the day, if we were the ones that made that conviction and we were part of that sentence, and we now look back and say that it's unjust, we should have an opportunity to do that. So trying to get that thinking, and it's really, I think part of this work is also reshaping what prosecutors do. And I think to some people that's challenging, because we all came to work, we inherited a system, we were told this is what we do as prosecutors. In the last, I would say 5-6 years, the public is now coming to the forefront and asking for a different perspective from prosecutors. And I think that has to continue. The public should be talking to their elected officials about what they expect from a prosecutor. So this notion of kind of reshaping what prosecutors do was, I think, it's still a challenge. And this law, as it's passed and now it's got to be implemented, it'll be really interesting to see kind of what happens and who embraces it. But I think it's really important for both Mary and I to do it well. And so I think, and I'm really glad that we've got the technical assistance from Hillary Blount's organization to help us think through this. But I do think like the first 3 cases that we're going to have, they'll be very public and hopefully they'll be received very well.
Brad, can I jump in a second?
No.
Just to build off of that.
Wasn't really a question. She was going to jump in. But no.
No, John is absolutely right. As I have discovered in my first year here, it is very easy for people in this community to talk about reform, but when you actually do it, people seem to disappear or join the chorus of criticism. This will be looked at, probably already is looked at by people who are aware of it as being a soft on crime approach. And, the first couple of people who get out, I fear the pressure that's on them. At some point in this process, something will go wrong, somebody will do something, and then there will be a whole bandwagon of this approach doesn't work, we have to get tough on crime. And so I think we have to be realistic about that. And I join John in saying, we really need your help. And we need your help not only during the good times or when we're talking about expungement. Most people can get on board with that, or re-entry, that kind of thing. But I would say the criticism is fairly bipartisan when you try to do the actual hard work of reform, when you try to focus on data, when you try to do the things that research tells us we need to do. All of a sudden, the people that you thought were even supportive are not. So that makes it really important for everybody in this room to be talking to their networks, to be talking to their elected officials, to empower them to hang in there and really support the idea of a safer public safety system. Because we haven't really had much of that conversation here in Minnesota, believe it or not, about the really tough work that needs to happen. We're all about expungement, reentry, which is wonderful, but we're not really quite there yet in terms of what makes us safer, and the fact that sending people to prison for very long periods of time does not make us safer, and that so many people who are in prison could live safely in the community. They could be there for their kids. We know that kids whose loved ones, their adults, are incarcerated are much more likely to become involved in the system. So there are a whole host of reasons why this is important, and we have to really be vigilant about the narrative here.
Can I add to that?
Please.
I just had an idea.
Yes.
Just building off what you were saying, what I just realized that doesn't happen is that we don't arm community members with the talking points about why this is actually leading to public safety, right? So I feel like we should circulate that, because there are very consistent resistance, there's very consistent messaging about why this is a bad idea. And they kind of boil down to things that are just not true, right? That victims hate this and the victims are opposed. That's just not been the case. I was just talking to a DA from San Diego, the 5th largest county in the country, who said that they have not yet had a single victim oppose a decision. Victims are engaged in a way that is through a trauma-informed lens. They're given an opportunity to participate in the process. And so I just feel like it might be helpful to give you all the language when you hear that, oh, this is making our communities unsafe. Statistically, no, it's not. Oh, victims aren't included in this, they hate this. No, they don't. So I just thought that as you're asking community members to talk to your electeds and also stand with your leaders here as they navigate this and have courage to be the first ones out to do this, it might be helpful to have you have that language as well, because it's all none of it's true. All of the things that people are saying about why it doesn't work, it's just all not true, and the numbers are there to support that.
Thank you. And I think the perspective is really important. There's not many things about getting over that I like, but it gives you a little perspective. And when I first started practicing law, and Justice Hanson can attest to this, the longest sentence you could get in Minnesota was 17 years. You'd be convicted of first-degree murder, and you'd be eligible for parole after 17 years. It is now, for first-degree premeditated murder, life without the possibility of parole. That was not even a sentence. It wasn't in anyone's mind. So it's not even necessarily new. It's more going back. I do think we have to address a really important question, though. In Minnesota, we have determinate sentencing. And the idea there is a person receives a sentence for the offense that they committed. The judge looks at the offense and the criminal history scores well. But essentially, you get sentenced for that offense. Isn't this seem to contradict that idea of determinate sentencing? The idea that you get a certain amount of time for something that you've done. That was the whole purpose of the guidelines. That's how it started. Aren't we changing that?
Are you looking at me?
I'm looking at all of you.
Okay. I think the idea of determinate sentencing or guidelines, in theory, was a good one. Hey, we need to remove the bias from this and treat everybody alike. But we know that's not true, right? We know there's all kinds of bias that impacts many of the subjective decisions that prosecutors and police and everybody else in the system make. Not necessarily intentional, but it is there, which is one of the reasons why we have such large racial disparities here. And so we know determinate sentencing isn't all that people probably thought it would be. The other big thing here is whenever we as prosecutors are making decisions, or judges for that matter, we're trying to look into the future, right? Like, where will this person be? What's in the best interest of public safety? And we are not mind readers. And so this is really helpful in allowing us to look at actual facts and look at a person who's been incarcerated and actually see where they are. We sent them to prison for X number of years, but now we get to see how are they doing? Could they be safe in the community? And we've never had that tool before. So I think it's complementary in a way that allows us to take a look at a person's life, what they've been doing in prison. And if they can be safe in the community, then it's probably time to release them. So I think I view it as being complementary, even acknowledging all the problems with the guidelines system that we have.
So I don't know if you're suggesting that somehow, like, this is I think that the theory or the principle of determinate sentences, right? And I think what Mary said about we're prioritizing that need for finality, or I guess, but the thing is, I think justice doesn't work that way. Things change and things can't always be concrete. I think sometimes we get stuck in that because there's other reasons why you want that finality. So I think about like when we worked in the child protection area, where basically the way that the law kind of is set up is that there needs to be a permanent decision made about whether or not a child would be removed from their parents. But what if there is a decision to do that, but what if that child never gets adopted and is actually wanting to reconcile with their parents? So we passed this bill that allows for reunification afterwards. And I remember like people in the system, a lot of judges and people who thought that was going against this notion of like, well, we made a final decision. This is what everybody has to live with. And that legislation ended up passing. And I think that's the part of justice that we need to grow and to evolve from, is that things just can't always be whatever happened 30 years ago or 20 years ago. Then what incentive is there for anybody to rehabilitate? What incentive, in fact, another conversation that we need to have is about what we do for victims as well. There is no finality for victims, even though there seems to be with the case, the conviction, and the sentence. There's a whole life of trauma and having to deal with not having your loved one there if it's in the context of a homicide. So things I think do change. And so I think that's important to allow for this mechanism because I think it actually improves the quality of justice.
And if I could jump on there too, the legal system is very entrenched in finality. Very entrenched, to the point that we have a Supreme Court that says it's okay to execute people who are factually innocent for procedural reasons. That's just crazy, right? And so I think this allows us to exercise some humility in the system. I've been a part of trials where I was sure the person was innocent and they were convicted. And there are some who would say there has to be some kind of sanctity to a jury verdict. But jurors make mistakes too. And jurors want mistakes corrected. There's forensic science that's allowed in that really wasn't science or shouldn't have been allowed in. So there are mistakes. We are human beings. We make mistakes. Judges make mistakes. And I think there's a resistance to acknowledging, hey, we thought we were doing what was right way back when, and it clearly has done some harm. And so we need to have the tools to address that kind of harm, understanding that science changes, witnesses change, all kinds of things change. And we in the system have to change along with that.
Billy, you're just not along like I am.
Well, that's fine.
Okay, but you know,
What they say.
yeah, exactly. I love the idea of emphasizing finality, right? That's a great phrase. The next question is, why are we looking to prosecutors for this, right? I mean, I think part of what I think you have to acknowledge is one of the reasons we have mass incarceration is because of prosecutors. And so why are we turning to prosecutors to correct this?
One of the things that has frustrated me a little bit in office, we get petitions for review, we get all kinds of letters from people who request some kind of relief. Some of them have lawyers, some of them don't. Some of them just have the resources or the connections to kind of get to us, and others don't. And so we've talked a little bit about how this is a data-based approach. And one thing we are doing is looking at data from the Department of Corrections. So looking at categories of cases. So when I think about this, I think of, we look at, age, how long somebody's been in prison, when did they get there in prison? So data-based approaches, and there are a lot of people who would slip through the cracks if somebody else was initiating this. And we also have access to victim witness services. And, Hillary was talking about victims, people who've been harmed being on board. We do have a way of reaching out to victims and getting their input and having their feedback come in. We also have the most power in the system. And having said that, I know a judge actually has to approve this petition that we put out there. But we do have the most power in the system. And so I think it is incumbent upon us who did create a lot of the harm here to use our resources, which are greater than defense, to go back and look at some of the sentences that we ourselves promoted at the time.
Yeah, and I just think it's important for the role of prosecutor to evolve. And I actually think that the role of prosecutor actually is set up to be a more expansive one. It just never played out that way. Where the role of the prosecutor, I think historically we have very much sided with the victim. The prosecutor will always say that we represent the public, but the way that the systems work out, the victim's perspective is going to be as a part of like how we consider a case. But I also think that the role of the prosecutor is not just about that victim, it's about the community, and the community includes those who are accused of crime, those who are convicted of crime, those who are sentenced to prison. And once we can embrace that, then I do think that prosecutors will be more concerned about reentry. They'll be concerned about what actually happens in a correctional environment. Are they actually getting rehabilitation? And we should care about people who are in prison, who have done everything that we've been asking them to do, and they don't need to be there anymore. And we should be open to that conversation and that question of, is there an appropriate thing that should be done for this individual? Because if we don't do that, then truly what we're really up to is we're just truly locking them up and throwing away the key. That's our role. And I don't want that to be the role of prosecutors. I want the role of a prosecutor to be mindful about the quality of justice for everybody in their community. And everybody in their community means those people that are incarcerated, it means those people that are harmed, it means literally everybody in our community.
I also think we have to start looking at ourselves when it comes to people who are harmed. I hear prosecutors, I hear a lot of people talk about speaking on behalf of victims, but it's only the type of victim that they find to be an acceptable victim, or somebody who wants a long prison sentence. And we know there are so many people who are harmed who actually don't want that. They want the person who harmed them to not do it again. They want them to be rehabilitated. They have all kinds of questions that never get answered by the traditional legal system. And so I'm thinking about a woman that I talked to last year who was carjacked, and it was very traumatic for her. And she was courageous enough to go on one of the local TV stations and talk about how the people that carjacked her looked very young. And she didn't want them to go to prison for a long period of time. And as a result of that, she was absolutely ostracized. She came upon a Facebook page criticizing her because she didn't fit the narrative of what some people want us to think that every single person who's harmed wants. So, and I also think back to an event convening that John and I went to in Montgomery, Alabama, and we heard the mother of a child who was shot in a drive-by. And she looked at us and she said, you should all, prosecutors, look in the mirror and ask yourselves why you're asking for what you're asking for. Is it for us or is it for you? Because when you tell us you're getting us justice by sending somebody to prison for a long period of time, then you set us up to think that sending somebody to prison for a long period of time is going to heal us. It's going to make us feel better. And so many people know that that isn't the case. So I think we have a lot of work to do in looking at why we ask for certain things. And if we are saying we're doing this on behalf of victims, are we? Or are we doing it on behalf of a narrative that we've all been sold, I think, through this entire system, that the harm that's been done to you or your loved one is measured by the length of a prison sentence? That's what we've all been sold for the entire system. And we have to re-examine that. And we have to re-examine it in large part for public safety, but also for those people who've been harmed. Because we're not helping them by using incarceration as the sole thing that's going to bring them something called justice or somehow heal their harm.
So, Hillary, that seems your organization is trying to revamp the role of the prosecutors, the whole idea, right?
Right. I mean, that was really the kind of the landscape, back in 2014 to 2017 when we were working on all these different reforms. And my job was to find people in law enforcement that could back the reforms. And there were these individual conversations with prosecutors that would say, I agree with what you're saying, but we can't, as prosecutors, come out and support this, whatever this measure is. And then equally, people that we were working with on the defense side would say, well, why would you engage prosecutors? Like, this isn't, both it's not their role, and they're never going to be part of the solution. And I think that what I saw then and what you're hearing now is just this concept of like everybody's some kind of monolith. Like victims all want one thing and prosecutors are all going to do this. And I think that was what I saw was really the danger, right? And we see it today with how divisive we are as a country. You're either for this or you're against this, and you're on this side or you're on that side. And we lose track of the issues, and we more prioritize what position we're in and what our role should be. And so that really was the impetus to this, is that, why does the role of the prosecutor have to be so narrow? Why can't there be an initiative where prosecutors and defense attorneys are working together collaboratively? coming together, and defense attorney might say, I have a client that I remember, received this really long sentence, and I've been in contact with him for the last 20 years. He's doing great. I want you to go take a look at it. And why can't the prosecutor say, okay, let's take a look at it, and let's sit down and have a conversation about what this kind of practice could look like. So, and I think that it's very dangerous to sort of silo. That's the whole reason why, as a prosecutor, we're kind of in this position to begin with, right? You're in this office and you have these blinders on, and you're not really supposed to think about the defendant, right, or the defendant's family. That's the defense attorney's job. Your job is to focus on the victim, and you're not supposed to worry about what happens when they go to prison, because there's a whole other system, the Department of Corrections, and they're going to figure all that other stuff out. So just kind of stay in your lane and do your job. And I did that. And then when I kind of came out of that and took the blinders off, I saw that all these other systems were broken and they weren't communicating with each other. So I think that this kind of role diversion is, obviously in some instances it makes sense, but in some ways we do have to think a bit more broadly. And I think prosecutor-initiated resentencing is exactly one of those ways to be thinking about it. And as John said, the definition of being a prosecutor, it's in the ABA standards, it's everywhere, that our job is to ensure justice for all parties that come into the justice system. We're supposed to be as concerned and as responsible for making sure that the constitutional rights of the defendants are protected. So if there's a person in prison that's there a day longer than they need to be, that is an unjust sentence, right? That's cruel and unusual punishment. So that's our responsibility. And so, we kind of hear it from a lot of different sides that, this shouldn't be the prosecutor's job, that this should be the defense's job. And I think that's a really dangerous narrative. If there's a fire up the street, right, it's not like everybody stays in their house and waits for the fire truck to show up, right? Everybody has to pitch in. And what we have as a country, right, the highest incarceration rate in the world here in the United States, we're on fire here, and we need every single actor in the justice system to be involved. We need every single person in this room to be involved. And so this is why this sort of urgency and the call to action of prosecutors, I think, is so critical.
Another issue we have to look at is who's going to get the second look. When I talk to people about this, they say, well, yeah, I can see giving people who are convicted of marijuana, possessive marijuana, let's give those folks a second look. That's not who's incarcerated. So how are you deciding who's going to get a second look? What do you the criteria? What's the process?
So what we're doing in Ramsey County is we've received a number, I knew right away that there would be, after this law would pass, there would be some letters coming from people, family members, wanting us to work, look at their particular case. So the first thing what we decided to do is not start with like a case by case approach, but really to be thoughtful. And I'm so grateful that we have the technical assistance for the people, and we can look to other jurisdictions across this country that have enacted prosecutor-initiated resentencing in their offices. But the first thing that we wanted to do is actually start digging deep into who is in prison, why are they there from my jurisdiction, right? To understand that particular landscape. So we've done that work. And then we also have a community advisory group. And we have been meeting with them to kind of think about what kind of categories that we want to start looking for people. So we want to start the process in Ramsey County by looking at certain types of categories. Now, interestingly, like the categories that we were very interested in before this law was passed, the legislature actually enacted reform in these particular areas. Like, for instance, a juvenile who was convicted for something and then had a really long sentence, obviously certified as an adult. That would have been a perfect category. Now there's a kind of a process for that, but there's still maybe some opportunity to look at that category. The felony murder law reform bill, there's now a process in place for that. We felt like that would be a good place to look as well. So our office will be working, to enact that part of, or to do that part of the law. So what we're looking at is we're starting with more of the non-violent offenses. who are people who are still in prison. We're looking at people in terms of like if, regardless of maybe what they've done, but if they're over the age of 50 or 55 and 60, and just looking and kind of understanding how many people we would have in each of these categories. I really think I feel like right now we're on the look for that perfect case, because I really believe that the first few cases coming out of Ramsey County or Hennepin County is just really going to matter for this work for the entire state. And so I think we're kind of in that process of trying to understand who these individuals are that are in prison from Ramsey County, and then from there, then we will be trying to contact these individuals.
Just want to give a shout out to people who were instrumental in changing the felony murder law are in attendance here, so thank you for being here. So what's been the national, I mean, are they, because it sounds like Mary and John are going to go slowly.
Right.
Has it evolved where people are willing to take on the more difficult cases, or are they still moving more slowly?
Yeah, I mean, it's a kind of a combination, and as has been mentioned already, I think the data piece is really important. And I'll just say that for anybody here that does have conversations with your county attorney, and they say to you, "I don't think there's anybody in prison that could benefit," please call us. We have all the data for the state, and we have a data scientist on our team that's been analyzing the data. Because it is true that there's a lot of sort of misunderstandings about who's still in prison and would there be somebody that could actually benefit from this. What we have seen across the country is that oftentimes the practice is to, it's like the African proverb, go slow alone or go far together. It has been to try to identify cases of people who are on the older side. So elderly, focusing on the elder population in prison, focusing on people who were younger at the time of their offense, so 14, 15, under the age of 18, and then people that have served already a really significant length of time. Those tend to be the areas that a lot of offices are focusing on. Obviously, as you can imagine, for young people, we want to get them out. They've been there too long, and then older people have the severely low recidivism rate, so that's something that is compelling to offices. What we always say when we support offices, as you kind of picked up, we work on passing these laws, but then we also partner with DA offices, county attorney offices, and basically do all the work for them. We don't want the concept of resource to be a barrier, right? Offices might say, we just don't have staff people to do this work, and we say, we'll do it. We don't want that to be an issue, and we're not making recommendations, we're not doing that, we're just working the cases up for them. Interfacing with people in prison, getting their support documents, and then giving the cases over so that could maybe reduce the burden of onboarding a new practice like this. But what we always say is, what is the starting criteria, right? Underline, emphasis, start, right? We understand that you want to start with a case that is going to be maybe the most compelling or it requires the most attention now, but the criteria must change over time. As you begin to understand a person's journey, for prosecutors that have never had a conversation with a person that's been in prison before or talked to their family members, over time the criteria must change because you have a lot of people in prison that need relief. So it does typically start slow, but what we have seen is we have offices, and we work with across the political spectrum. Again, this is a role for a prosecutor. This is not if you're progressive, you do it. If you're conservative, you don't have a responsibility. That is not what this is. This is the role of a prosecutor. All prosecutors need to be doing this work. And what we have seen is prosecutors that say, okay, we'll start there, but I'm never going to do an attempted murder case, or I'm never going to do a gang case, or I'm never going to, right? And we're like, okay, we'll start with the one you want to start with. And over time, the goal is that we will look beyond what the offense was, and we'll really start to look at the person. We'll really start to look at the context and the drivers that the person was facing at the time of the offense. And most importantly, we're going to look at all the things they've been doing since they've been in prison that addresses all of those drivers. And now there's not really a reason for them to be incarcerated anymore. And while it is slow, this is slow, we do have several prosecutors over time that have begun to they say that I can't believe as a 26-year veteran gang prosecutor, I'm in court asking the court to release this former gang member from prison. And then we get to have him go and meet this person when they've come home. And so all of this has been really helpful. This sort of what we see is restoration of humanity back into the justice system. And while it is a slow process, we think it is probably a safer way to begin. It is not surprising to anybody here that there is a certain faction of the world that's waiting for somebody to get out and do something so they can jump on it and get it to the media. So our approach and the way we encourage this work is to be meticulous and be careful, but it has to be a steady drumbeat, and we do need to look beyond the kinds of cases we started with and begin to look at and consistently look at the person.
We we haven't announced our criteria yet, and part of that, as I mentioned before, Hennepin County has 25% of the prison population. So we are looking at all the data, we're looking at mandatory minimum sentences, we're looking at sentences that may have changed, but it wasn't retroactive. I know from working in the system, there are a lot of aiding and abetting cases. So there are different categories that we are looking at. We are also working with St. Thomas Law School on our process. And one thing I should say that's really important to me, because I was a public defender, anything that we do, or anybody that we petition to release, somebody out there is going to say it was because I was a public defender or something like that. It is really important to me that the people who benefit from this have to deal with that as minimally as possible. So one thing that we have done in the office, we built out a separate division that's never existed before. That's our professional standards division, headed by Claire Deagle. And she and Jill Beretta, who is here, is working on PIR for us. But they are coming up with criteria, and a lot of that is pretty removed from me, which I think is a really good idea. We want to have objective criteria. We want this to be data-based so that it is legitimate, and that if we petition for somebody to get their sentence altered, it's not because I knew the person or I knew somebody about them. So that process is really important for legitimacy for the community and the people who are involved.
I could go on forever with the law professor after all, but I want to give a chance if you have questions in the audience.
Hi there. Here. Todd, I'm a student here. I just have a question. You spoke a lot about how one of the greatest barriers to implementing these kinds of things are the need for maybe a mentality shift or an identity shift for the prosecutors who are who are fighting against these kinds of systems. My question is, means as leaders in the field, as public servants, what concrete steps are you taking to ensure that that mentality change actually happens?
I think I understood.
So we have 87 county attorneys in Minnesota. They are independent electeds, and what I hear often is that there's this fear of resources. How are we going to do this? What's going to happen? There's a fear because they are elected in their own communities as to what their law enforcement or what whoever might say. So I think from my perspective, I try to be supportive. I try to push and nudge. I offer our resources in any way possible to the other county attorneys. We have a Zoom meeting every Wednesday morning at 8 to talk about issues. So really trying to find commonalities and reasons for why other county attorneys should really look at this. Ultimately, it's up to them. Neither one of us can push them, nobody can push them into doing it, but a lot of what they have to consider, frankly, are political considerations and resource considerations. So if you know people who live in those communities, helping bolster them and saying, hey, this is something that we want is really important.
But I think Hillary would have a great perspective from California because the law has been around for a while. And we do have district attorneys of all stripes embracing this. And I think that's what I hope that we can get to that place where we've got it, it's, you're just looking at this from a justice perspective and you're recognizing that your public is supportive of these things. And I think they've had things that have gone wrong, but at the same time, they've had some just really beautiful, amazing stories of people being released and being done so in an appropriate way, where there have been victims in support of it. And so maybe Hillary, you should talk about that.
Sure. I think the one thing that I would say in terms of the concrete step that we take is that we meet every prosecutor where they're at. And I think that maybe that approach is a little bit different. If they want to look at 150 cases, wonderful. You want to look at one, that's great too. If you just want to learn a little bit more about what's happening in other counties, we'll show up for that. I think it's that approach that everybody is in a kind of a different position, or you mentioned the word courage, or there's an election cycle. We really try to just meet them wherever they are on that sort of ideological journey. We're not asking them to change their whole identity. We're asking them to think about new innovations. And it has been very successful in California. And let me just sort of footnote the word successful, because I think for anybody in prison, the idea that this is going to be timely or take a lot of time is not what they want to hear or what they deserve to hear. But it is the reality that it is education, it is conversations, it is having one prosecutor talk to another prosecutor, it is try to rise above the you're a former public defender and you're I'm moving away from all of that, right? It really shouldn't matter about those kind of identity politics, and it really is supposed to be about there are people in prison that don't need to be there. We think there's probably about 25% of the prison population that could be safely released. There's reports that have come out that said that. Everybody needs to figure out how to get these people home. It's better for our community for people to be released. It is more cost effective. It's $110,000 per year per person in California. We all can think about other ways to spend that money. And so the concrete next steps have just been to continuing to talk to more people and have more conversations, have courageous conversations, and really try to have as big of a tent as possible to bring as many people along and as many people into this kind of new way of thinking about justice.
Any other questions? Okay, we have a mic.
My question is for you. In the other states, including California, et cetera, I think one of the greatest discrepancies or the greatest vacuums in our system, especially when we have violent offenders, is the victim impact and the inability of the prosecutor defense, the entire system, to create a space for restorative justice and the restorative conversation. This past commutation hearing in Minnesota, we had a beautiful situation where a victim's family in a homicide reached out to one of the aiders and abettors for questions to be answered years ago. And this developed into this incredible relationship of healing for all of them. And they showed up at that hearing to say, we want him home, he's now with our family, right? Not the norm. And I think that norm is something we as a society have created, is this space where we keep the victims and the impacted person, the person who caused this harm, so separate. And in fact, in Minnesota, for the most part, it's illegal for them to cross-pace other than put a letter in an electronic vein, right, to maybe the victim might find out about it, right? So have you had county attorneys, DA's office that have started to bring that approach on the front end and the back end? Because I'm assuming if we have a victim's family that comes up to Mary, John, whomever, and says, we support this, we believe in what's happening, and we support this, it's going to be an easier process than we have an adversarial where they believe justice for them is determined by the sentence.
Yeah, I mean, I'll just be, this is recorded, but I'll just be candid anyway. But, I will say that just so much of this experience has been one of recognizing that there are things that we say that we do, but we don't actually do them. And so in the beginning of this work, it was, restorative justice was thrown around a lot as a practice that was happening in a lot of offices. And so we thought we would just easily take that model and apply it to the back end. And when we looked a little bit deeper, we saw that not only was it not being done, but it wasn't being done according to the standards of actual practitioners. So there was a lot of gaps there that we found. We're working on a kind of a toolkit around some back-end post-conviction restorative justice practices and working with names of groups that you would probably recognize. But what we have found is that people that work in victim witness assistance, they have said repeatedly, we don't know how to have these conversations. We have conversations to tell people what the sentence is going to be, and then we get them victim compensation. But we don't know how to have conversations to say, okay, this is 20 years later, this is coming back up. We don't know how to have those kinds of conversations. So there's been a lot of fumbling through and trying to do it in a trauma-informed way, but there have been some offices that have done a remarkable job, and this has been some live restorative justice practices that have happened in the court where the judges have provided an opportunity for a dialogue between the victim's family, and then also the person that is up for the resentencing hearing, where information was shared. One of the things that when we are working with offices is a little bit of training around how to have the conversation initially with victims and how powerful it is to approach the victims and say, a decision has not been made. This is not a FYI, this person's coming home next week. This is a new innovation. This is something we're thinking about, but would you be open to a conversation? And then typically the next conversation is sharing those letters. Would you be open to hearing what the incarcerated person has been wanting to say to you for the last 15 years? Would you be open to hearing about what was going on for him at the time? And would you be open to hearing about what he's been doing since he's been inside? That has been, kind of pulled from various restorative justice practices, and that has been helpful. But I think the most, and I'm looking this way because I think he said this was a judge here. But what we have heard to be the most powerful is when there's been an actual dialogue that's happening, facilitated by the court. But again, even though we've been at this for a couple of years, there's a lot of gaps. There's a lot more improvements to be made, and this is the primary issue that we've been hearing about from offices across the country. How do we do this? How do we do it well? And how do we make sure victims through this process aren't re-traumatized? And then also there can be some powerful healing, especially for the incarcerated person. For them to be able to communicate and convey those words is also part of their healing journey, and also creates the closure for them, and also the assurance for us that they're not coming out reoffending. They've now finally completely closed that entire chapter. So, but lots more work to do on that.
I think we're about to have lunch, and I know I don't want to get in the way of lunch. Do you have any last sentence or two you want to?
Yeah, I'll end with how I started. Everything that happens in the criminal legal system, criminal justice system, really belongs to all of you. And this is a really critical time for communities to be talking about the quality of justice. We have been for quite some time, but right now I feel like it's become really polarized. And somehow we got to figure out a way to bring it back together. And I think all of you, I just want to encourage you to stay with this conversation and engage others to be a part of these conversations, and ultimately supporting the work that's happening. And what both Mary and I are trying to do is just improve the quality of justice for everybody.
That's a great place to end.
Can I say one more thing?
Please.
I just want to mention, if anybody here is familiar with the Participatory Defense Network, anybody know who that is? Okay, we should talk afterwards too, because they're doing incredible things with organizing families and bringing cases to DAs and county attorneys as well. So I know you have a pretty strong network here in the state, so just let's talk afterwards about that.
Thank you, Pam.